And so that's where I think the distinction with the personality breaks down. You know, maybe if there's a hypothetical situation where
I mean, but you know, it was the LLC that paid Ramsey. There's no written contract, and you know, I'm not quite sure what the parameters of what would the parameters of this legal relationship be that would allow him to, other than, you know, that Ramsey wants to get paid more, but what are the legal parameters that mean that he is in total control of this?
he being Mr. Galden?
Yes, sir.
Because the whole purpose of having Mr. Ramsey was for the purpose of filming Mr. Galden for Mr. Galden's artistic use down the road if he wanted to do it.
Well, I know that's what he wanted, but he didn't have anything in writing to declare this is my. In other words, I think, and maybe I was just not focusing, but in Judge Willett's deal, doesn't the wedding photographer normally says, I have copyright protection on this, and you've got to pay me again in order to get copies of the photos.
Yeah, I understand that point, but I don't believe that's the situation that we have here. And we're not required to necessarily have a written contract with Mr. Ramsey. You know, and I think that is one of the things.
Again, what's your best case for that proposition?
Well, the written requirement is dealing with the nuances of a pure Copyright Act charge, or suit. But as the district court put in its ruling that, you know, the common law rights on property preceded the Copyright Act, you know, my best case to argue to this court is really dealing with how the court should look at the district court's findings, and that's the Massey decision. While this court is looking at standing de novo, it is the factual determinations of the district court that is going to be by clear error. And the court found that there was a relationship between Contrell Galden and Marvin Ramsey that existed in the past. The court found that B-roll footage is something that Mr. Galden used for his videos, and that he had the ability to choose when it was released and when it was not released.
Well, isn't this arguably a question of law rather than fact? Because even if we assume that he had a subjective expectation of privacy, the next part of that standard from the Supreme Court's perspective is whether society would regard this as reasonable. And, you know, we determine that, we don't take a poll of society, we rely on the Supreme Court authorities for that.
Yeah, and I think there's a couple of cases that we can show that would demonstrate that that our subjective belief is objectively reasonable. You know, when we look at the Riley decision dealing with cell phones, you know, one of the things that the court said that made cell phones different than other objects in property was that there's going to be a lot of video on here, and it could go back for a long period of time. And so in that situation, someone's protected interest in their videos is certainly recognized. And also the Byrd decision where, you know, we've in my opinion, in reading Byrd, we're now saying you don't have to be the owner of the car, you don't have to be the authorized person by Hertz or whatever to drive the car or to have standing to challenge a search of the car. If you're driving it, you know, it's objectively reasonable that you do have standing in this case. And so I think that there is a little bit of a broader interpretation of standing than what the government is proposing here based on those two decisions. And then even Carpenter, the decision where even your movements in the public, that the fact that it's being tracked by the different phone towers, you would still need a warrant for that.
All those were, I mean, you know, where this will go, case will go, I'm not certain, but in Riley and Carpenter, the defendant owned the cell phone.
And it's our position that Mr. Galden owns his name, image, and likeness. And
that would be a bold, I mean, that's almost as broad a holding as the one one that I mentioned to the government, that you have, if you forfeit privacy in one photo, you forfeit them in all. To say it's your name and therefore you're protected in all is a very broad.
Well, but it's within the context, Your Honor, of him having the videographer here for him to document his name, image, and likeness for when we decide that we want to release it for commercial use. So it's not quite as broad as I guess I maybe made it sound out to be, Your Honor.